one of my co-chairs, Mitch Mitchelson, is moderating this panel this morning. Mitch is a longtime partner at Alston and Bird. Known him for years and worked with him when I was there. He's a University of Chicago Law School graduate, and unfortunately, he's a Duke undergrad. And he was an assistant U.S. attorney in the Middle District of Florida for many years with some great distinction there. He has a white-collar practice here in Atlanta. He's former chair of the white-collar group at Alston and Bird and chair of the False Claims Act working group at Alston and Bird and co-chairs their healthcare litigation team. He clerked on the Ninth Circuit Court of Appeals. There's a lot more I could share with you about many of his accomplishments, but we need to get moving on the program. So, Mitch, it's all yours. Good morning.
So, good morning, everyone. Thanks for coming back. It's a pleasure to get an opportunity to have a panel of this level of accomplishment. This is one of the things about this program is when you put it together, you don't know exactly how all the panels are going to fall into place. I'm humbled, not having a background steeped in trying public corruption cases, to have a group of people who are incredibly accomplished in that area, and so it's really my honor today to kind of try to ask them the best questions I can, so that they can impart to you the deep experience that they all have from their work in this area. At the far end of the panel, the table here today, on the other side is my partner Jenny Kramer, who is in Alston and Bird's New York office. Jenny was recently named one of the leading female investigative lawyers in the country. She is an experienced former federal prosecutor. She's a partner in our New York office. Her practice involves, she is a truly accomplished trial lawyer. She tried the Menendez case with Abby, and is really one of the great up-and-coming litigators in New York that is going to be, successful there for many, many years to come, trying high-profile white-collar cases. It's really been one of the most rewarding things this year for me to get to know Jenny in cases, and to spend time practicing law with her has been really truly a blessing for me. Next to her is Abby Lowell, who really does not need an introduction for me to be known in this room. He is, simply put, one of the greatest trial lawyers this country has seen. He has tried some of the biggest cases in the white-collar area and in the public corruption area. His resume is as accomplished as any trial lawyer in the country. In addition to doing the Edwards case, he of course tried the Menendez case, the Espy case, and any number of high-profile white-collar cases. He is a double Columbia grad, still spends a fair amount of time working with his alma mater, doing things to improve the legal profession by passing on his knowledge to the next generation of white-collar lawyers, and considers that to be one of his core missions as a practitioner, and lawyers for many years to come will be grateful for his commitment to that goal. And to my right is Kurt Erskine. Kurt and I go back, 17 years, Kurt? Mm-hmm. When you started as an associate at Alston and Bird. He is now the first assistant U.S. attorney in the Northern District of Georgia. Before he was the first assistant, he was the chief of the public corruption section in the U.S. Attorney's Office, and so brings years of prosecution experience in this area to this panel. So it's like I said, humbling to be here and ask this distinguished group of lawyers questions about how they go about thinking about, litigating, and trying public corruption cases. So I'm going to start today with Kurt to get a sense or an overview of the government's decision-making process when it comes to thinking about how to charge these kinds of cases, what statutory vehicle to use. When a case comes to your office, you have a menu of statutes available to you. But before you talk a little bit about sort of which item off the menu you want to order for a statutory vehicle, Kurt. Tell me a little bit about, what you view as the U.S. Attorney's Office or federal prosecutor's role in enforcing statutes dealing with public corruption versus state officials, and whether or not you see the federal government as having a different or unique role in these kinds of cases.
So when an allegation of public corruption comes to us, one of the very first things that we do is we look at it and triage it, and necessary in that analysis is thinking about what our resources are. We have an office that now has about 103 prosecutors. The public corruption section is 3 dedicated prosecutors, but we pull across the office and ask other prosecutors in different sections based on the nature of the allegation to often jump in on these cases. Most of the cases, not all, we do everything from police officers and low-level public employees to expansive investigations that may take years of grand jury work and may result in a trial, may result in multiple indictments or potentially convictions. And so we have to there's a resource analysis that starts the dialogue.
So let me give you an example,
All right.
Kurt, so that to see whether or not this would be a case that your office would take as opposed to leaving it to state officials to prosecute. Suppose you had a fraud on a state program that also received federal program money. So it received more than $10,000 of federal money a year, involved more than $5,000 of alleged corruption.
Right.
So it would fit within the ambit of Section 666. How would your office look at and weigh whether or not that's a case that you would leave for the state prosecutors to handle or for your office to take as a federal matter? What would be the considerations that you would analyze in determining whether to use your 3 lawyers and limited federal resources to bring that case into the office, or to leave it to state officials to prosecute?
Right, so with that as the backdrop, we're looking at, is this a single instance, say, where somebody has embezzled a relatively small amount of money, and it's a public employee who has had access to that money? Is it a one-off, or is this a system that has degraded to a point where others are involved, many people are involved, or lots of money is involved? Does it have significant public import? Is it something where the people's belief in government, people's concern about the way in government is organized or in the integrity of government would be shaken if we didn't intervene? We also take into consideration the fact, is there anybody else out there who would be in a position to prosecute it? And we have done some cases involving state and local jurisdictions, county government, where we take into account the analysis is the DA in a position to prosecute that, him or herself? And keep in mind, in Georgia, and I'm speaking from a Georgia perspective, the DAs are elected, the judges are elected, and when these cases get tried in front of a county jury, there's a lot of state and local politics that occur naturally within that environment. It's also, these cases tend to be very resource intensive, especially when we have a very long and drawn-out investigation. And that, in some jurisdictions, and we go all the way from very sophisticated DA's offices, like in the metro area, all the way up to North Georgia, where they don't have those kinds of resources. And so that's another factor that figures into us. Now we're going to be drawing on a couple of statutes. So to touch on your question, we're going to be looking at 666A. We're going to be looking at its use, but not just 666. We're also looking at honest services where there's a kickback or a bribe. It's still alive post-skilling, and so that's a vehicle. Obviously, if it's a federal employee, we're looking at 201. That's a concern, but tax often fits into these cases as well. There's often a tax count where somebody has taken bribes and they've used the money, they bought the car, bought the house, whatever it may be, and they have said that, I make X on my tax returns, but you see lots of income in addition to that. So that is not uncommon. Occasionally we'll charge a Hobbs Act, 1951 extortion. That is less frequent. You see that used more often, at least in my practice, in the context of law enforcement corruption, where you have, say, a police officer who's shaking down people.
Abby, most of these cases involve, often, and the ones that you've handled, high-profile individuals. The allegations that the government makes in the indictment goes to the core of who they are. It challenges their integrity at a base level, in addition to the seriousness of the criminal sanctions that clients face if Kurt or his colleagues bring a federal case in alleging any of the corruption statutes, 201, or like in the Menendez case, you have a sitting senator who's accused of corruption. When the indictment is returned and you're engaged, how do you, one, sort of counsel your clients to deal with the professional fallout of the allegation? And how do you attempt to manage the press and the media, both from a standpoint of protecting your client's reputation and integrity, and also positioning your client's case for trial?
So, Mitch, I think two things. First, I'd like to say that all areas of white-collar practice are unique. There are definitely issues, as you just identified, that come into play when it's a public official, especially elected official. I'll come back to that in about 30 seconds. But I do want you to know that some of these same issues and considerations would apply in a number of different circumstances that you will find. You represent a CEO, CFO, COO of a company that's publicly traded. There's an allegation of wrongdoing in a white-collar way. The hue and cry for the company to take action on that person, to fire them, suspend them, et cetera, is immediate, just as there is the hue and cry whenever a public official is under investigation for that public official to resign. And it doesn't even have to be a publicly traded company. We don't live in a country, I mean, I don't know if we ever did, but my view is that in the criminal way, especially given the proliferation of cases, there's more a presumption of guilt than presumption of innocence, and that's especially true the higher up on the food chain your would-be defendant or target is. I wanted to start by saying that because while I think there's some unique aspects to representing a public official, I think these pressures apply to all of your cases when you're representing an individual in a high profile. And by high profile, it doesn't have to be somebody running for president. It doesn't have to be a sitting United States senator. In your communities, it could be the head of the county council. It could be the person who's in charge of the biggest company in your town. Those are high profile cases. And so the dynamic that applies in my high profile cases is exactly the same that would apply in yours. It just may be on a different scale. As to each of those individuals, a public official or a CEO or somebody who's in the limelight, there's the balance between, depending on where the cycle is, figuring out first and foremost, I always tell people there are 3 criteria that you have to apply as a lawyer in any of these cases. The first and foremost and the most important is the law. I mean, we have to figure out what is the legal strategy that's going to keep our client free. Hopefully, the next criteria is, and what is that strategy that's going to keep that person viable in his or her situation? Make sure that she or he doesn't get forced out of her job, resigned, impeached, or whatever. And then the third is the court of public opinion. And the court of public opinion is the third part, but it plays out on the first 2. If in the world the person is seen as just the most horrendous human being, not only does that affect the people that are asking that person to leave her job, but it also infects the jury pool if you're going to trial, and therefore each of those 3 pieces interact, they interrelate. And what has been the need of the cases that I and my colleagues have done is that we are confronted with that analysis, that 3-part analysis in every case I've ever done. And Menendez is an example. So the Menendez case came on the public scene 7 days before his election in 2012 with a leak of grand jury material of the most horrendous kind. That was when somebody was professing that he and his co-defendant, not yet a co-defendant, had engaged in underage prostitution, which was ridiculously wrong. But that's what went out there right before the election. And then the investigation got serious about the nature of their relationship. But when it did and he got reelected, that meant that he had 6 years as a senator to figure out what's next. And his indictment occurred in 2015, so that allowed there to be another 3 years before he was going to stand for election. So there, the issue was, what do you use those 3 years for? Can you sustain your political enemies from saying you need to resign your seat? like if he was the CEO, the board of directors saying you have to step down, and then how do you use that time? So I guess that's a long-winded answer, but the point is there are 3 areas. They interrelate. You have to take them into account. They are more take accountable in public corruption, high-profile people, but I want to advise that this is an analysis that you all should do in almost any white-collar case about an individual.
Jenny, what was the impact on Senator Menendez when these charges were returned?
That's a loaded question. I think as Abby was just discussing, given the 3 kind of approaches that need to be taken in any case of this nature, and in particular a case that's launched against a sitting senator, I had literally just joined Chadbourne in January of 15, and he was indicted on April 1st.
Fool's Day.
Yeah, April Fool's Day. And I had never met him in person. And it was that event that brought us in the same space and stratosphere. Abby and I went to court together, obviously with the senator, for the arraignment. And I've said this 1,000 times to people, in as much as clients are concerned. I still think he's one of the best clients anybody could ever wish or hope for. His steadfast ability to maintain composure in light of the impact of all that was occurring, and maybe something that fed into that ability was what Abby was just discussing with the years-long process that this had been. I mean, this investigation had been a storm cloud over his life for years while being a sitting senator. And I think there was some part of the indictment that enabled us to fight the charges. Finally, you know, it had resolved in the legal process so that we could fight back appropriately. The best result obviously would have been the case not being brought at all, and we still believe it never should have been brought. And I think that's been also kind of agreed upon after having a 3-month trial with a hung jury 10-2 in favor of acquittal,
Right.
and the government announcing its intention to not retry the case ultimately. But I think the impact on him, no one could really describe it other than the senator himself. But I was constantly amazed with his composure, professionalism, and approach. And I think all along he knew and hoped that justice would prevail and that the system would work. And believe me, we had every obstacle imaginable in the pursuit of this defense.
I mean, it was an incredible outcome. I mean, it was a victory in every sense of the word. I mean, other than a couple of, you know.
So later, let's tell you the story about the one holdout juror and how I wanted to strike that person, but our co-defense didn't. No, but
No, I want to hear that story. Let's hear that story. Abby, which juror was it? What kind of juror was it? You don't have to give the name, but tell us about that juror.
So we had one peremptory challenge left, and we were collaborating on all of our peremptory challenges, of course. You know how that is. I mean, it's a science in small measure, and it's seat of your pants by a large measure. And there was this one man, was one person, and then there was this woman, and they were both sort of quirky. And the man's quirkiness was that it was clear that he did not want to get on the jury. He kept talking about having a girlfriend who was a veterinarian, who had to deal with drug companies, and part of the allegations in this case was the misuse. There was not a Medicaid fraud, but the idea was that the senator intervened on behalf of his friend to help him get a reimbursement issue through HHS. So there was a medical component, if you will. And this guy made it very clear in his answers that he wasn't gung-ho on being on this case. And his girlfriend had something to do with a fight with the drug company. So that made the drug company made our co-defendant, who was the doctor, interested in this juror being a juror, this would-be juror being a juror. However, when we were up at the bench, the prosecutor wanted to get rid of this person. Now, I don't have a lot of rules, but one of my rules in life is anything my opponent wants, I don't want, and anything that my opponent doesn't want, I want. So I started off with thinking, this guy's a little quirky, I don't get him, and the prosecutor doesn't want him, wants him, so I didn't know what to do. Anyway, collegiality would have failed, and we put him on. And he was a large person, and he sat in the back of the jury box for a long time, for the long trial, and there were times where it was like By the way, when do juries, between the time that they're summoned and the time they get to court, go to jury school and be told that they're supposed to have poker faces? Where does that, I looked at the manual, and so they don't ever look at you or talk to you or whatever. Anyway, the point is he would sit there with his arms folded, and it just, I don't know. So everybody thought we didn't know about him. Bottom line is, jury comes out, find out what happens. There were various times that the votes were 11-1. He was the one. But we had this little argument in the beginning where I said I want the guy struck, and my co-defense counsel said, no, I have a good feeling about him. And I said, no, I have a bad feeling about him. And that's what happened.
Yeah, I know. It really argues for the floating peremptory, right, where you could just do it at any point in the trial.
Right,
that would make work a little more interesting.
Giving me, well, the other thing about this, besides the interesting anecdote, because probably it's happened to any of you out there, the same kind of thing, was one of the problems is you have a co-defendant case with a very high-profile set of clients in a very political atmosphere, and the judge would not give us more peremptory challenges than the statutory 10-6. And that was one of the things we asked for, and of course, because we asked for it, the answer was no. But that's an example. This is a case with a co-defendant in a high-profile case that had been covered in the newspapers every single day for years and years, and a jury pool of hundreds. What would have been the skin off the back of the judge to say, okay, especially because we had to collaborate, it's 16 and 12. I don't know what it was, so we didn't get it.
I thought the interesting thing, one of the most interesting things about the Menendez case is it got that kind of wide media coverage. And people spoke a lot after the McDonald case about how the law would be applied in Menendez. But at the end of the day, that case came down to you making an argument about whether this was a case about friendship or corruption. And I think it makes, a lot, we can sit here and break down Section 201 and talk about how the law has evolved. But you made that argument in that case something much more simple and much more sort of primal, which was to sort of invite the jury to look past the elements of the offense and really to think about the nature of the relationship between the parties that were involved in the allegation of corruption, and to try to define it in their minds in human terms. So can you talk a little bit about that and how, when as a trial lawyer, you decide to not make a technical argument on the elements of the statute, but to appeal to the human core about the nature of something fundamental that makes the difference in a courtroom?
Let me take the first answer, but I'd like her to do the other side of it, which is how do you, when you have to be the person with the burden of proof, to make sure every element is covered with evidence, not get bogged down in the formula, and also can step back? I think it would be very interesting to hear his point of view. So let me take the first piece of it. Anybody here besides me went to Columbia College? No? So Columbia College had a core curriculum. Core curriculum means you have to take a bunch of things. One of the things I had to take was art history. My spouse says I went to charm school. And I took art history, and I studied Michelangelo. I tell you the story because in the autobiography of Michelangelo, there's a very famous quote that I've used 100 times when I teach, and Jenny's going to throw up because I've used it so often. When asked about his sculpture, Michelangelo, this was after he did David, they said, how do you sculpt? And he said, in words probably Italian, he said, it's very simple. I look at the medium, I look at the marble, and I chip away what's not the art. It's a fabulous expression, and that's the theory of my cases. Not to try to compare myself to the art of Michelangelo, but it's a lovely concept. And so what I try to do is I look at the case, and I chip away what's not the art. And what the art was in Menendez, at the end of the day, was the fundamental nature of a 25-year friendship. In the John Edwards case in North Carolina, where, given the irony of what's going on in Washington, there was an allegation that a private person giving another private person money to cover up an affair or a personal relationship could be an excessive campaign contribution, and John Edwards not being a very attractive person, well, he's an attractive person, he wasn't an attractive defendant, because of what his situation was with his wife and family, et cetera. My closing argument started with the following phrase: there's a difference between a sin and a federal crime. And the second sentence was, during the trial, you've seen 2 books in the courtroom. On the witness's desk, there has been a Bible, and on the prosecutor's desk has been the criminal law. And if you've paid attention, those 2 books have never stood next to each other. That's your theory of this case. So you chip away what's not the art. And in Menendez, they wanted to say that a 25-year relationship could be corrupted and become a case of corruption and conspiracy. And we decided that we could prove our case of being a friendship. This is one of the evidence that we were able to get in. It's a picture of the 2 co-defendants at the doctor's friend's, quote, villa in the Dominican Republic. It's his family house there, sitting on the back porch. As they've done many times, you'll see that there's drink in one hand, and you'll see the man on the right, the co-defendant, Dr. Milligan, is doing something. You know what they're doing? They're singing. And that's what was described to the jury. So if you had to chip away what's not the art, and your theory of the case is friendship, this was a powerful piece of evidence.
Yeah.
So I wonder, Kurt, when you have to do the burden of proof, and you have to sort through 666 or 201 or whatever, how do you come up with the theme that is in addition to your elements of proof?
I mean, I think you have to be absolutely relentless on what that theme is of your case. We're doing exactly the same thing on the other side. We're looking at, we are presented with a long investigation, say, where we've looked at somebody and we've done lots of grand jury work, we've done lots of interviews, we've done lots of work to develop the case and make sure that we've done our due diligence before we ever bring a federal indictment against somebody, because we're mindful, we're incredibly cognizant of the fact that that is going to change their life in important and significant and often devastating ways. And so we want to be certain in that. But our job at trial is then to take the law and to take those facts and whittle them down and focus on what's important in the case. I mean, if you read 666 and look at it, it's a very technical statute. Some think it's a dumpster fire. And juries get confused very quickly about, some of the predicates, and you have to meet $10,000, and it is is reward covered or gratuities covered, and so they can get very bogged down in those details, and you have to avoid getting bogged down in some of those details and focus on what really matters. And for a jury to convict in one of these cases, they have to feel that the system has been undermined in a way that is criminal. They have to believe that the backroom deal happened. They have to believe that the public interest was thwarted to the benefit of an individual. And if you don't prove that to them beyond a reasonable doubt, they will not convict. They will get lost in the weeds. They will acquit, as perhaps well they should. So we spend a lot of time, even at the pre-indictment stage, saying, what matters here? What is important? Now, having said that, that doesn't mean we don't kick the tires a lot. We look at the cases, we make sure that there are federal funds. We make, if it's a 666, we make sure that we can show that the wire went interstate. We do all of that technical analysis, but when it comes down to it, we ask ourselves, is this a federal case? Is this something that we want to come in on, use our valuable resources for, and is it important that we be here in this space? Win, lose, or draw.
I'm not doing enough cases in the Northern District of Georgia. I mean, I want your analysis. I'm going to tell other people that's what you do.
Well, to all of the points that you were just making, one of the tactics used by the prosecution throughout the course of the trial was something I certainly had never done as an assistant U.S. attorney, and I didn't know we were able to do, which was call their case agent, who was sitting there for the duration of the trial 4 times, right? 4 times throughout the course of the trial. And each time the agent was called to the stand, because you were just talking about, Kurt, the need for documents and evidence, I will tell you there was not one document, not one witness, not one anything in the Menendez trial that proved anything close to a crime. It was all about friendship. And because no evidence of a crime existed, this case agent repeatedly would take the stand and testify And through this agent, the government used him as a conduit to move into evidence volumes of emails that were largely irrelevant because the proper witnesses to authenticate those emails would have been bad witnesses for the government. And the judge allowed this to occur throughout the course of the trial. And as I mentioned earlier, there were many, many obstacles. So to all of the points you were just making, and Abby's point about wanting to try a case here, it really...
No, I want him to decline a case here
Decline
because
a case.
because he's so thorough.
Exactly.
That's what I want to do.
Exactly. I think all of the kind of gaping holes in the case that was ultimately brought were well evidenced by the lack of any evidence and the attempt to make up for that lack of evidence by calling the case agent repeatedly.
Let me put a finer point on what Jenny said so that this is clear, because this is a tactic I had not seen in any of my cases. And I have to say, I mean, kudos to the government for trying it, because it's a pretty effective way if you own a witness and get the witness can say whatever you want the witness to say, because he happens to be sitting at your desk for the 12 weeks of the trial. This is what they did. So there was no, the public corruption case is a quid pro quo. It has to, it was bribery. It has to be this for that. It has to be an agreement. Okay, we all know that. There was no email, no conversation, no snitch, no person who said, I overheard the conversation, where they said, if you do this, I'll do that. There was nothing that does that. In most cases, you have that, right? In one way or another. If nothing else, you have a cooperating witness against whom a deal had been made or whatever. They didn't have that. Good for us. But they were smart enough to realize they didn't have that. This is what they did. Clever, cynical, objectionable, annoying, you can pick your word. The agent would come 4 times at various places along the way and make the connection of the dots by the coincidence of timing. So the agent would come on and say, well, what happened on this period of time? Well, the senator stayed at the guy's house and he flew on his plane and they exchanged gifts. And what happened at the same time, whether it was right around then or not? Oh, the senator called the Department of HHS. The senator made a phone call to Customs and Border Protection. And then the prosecutor would be at the easel and would take one side and other side and connect them literally with a diagram showing that the dots connected. This was a staged presentation to show a quid pro quo when, again, the evidence didn't have a witness. So they invented a witness. Now, that was smart, given that there was no evidence, but it also allowed us to tell the jury what they had just done. I've spoken to 6 or 7 members of the jury. I try to do that in every case, win or lose. And they didn't appreciate that.
Kurt, when you were brought an allegation of corruption by a public official, and you're determining whether or not to exercise your power as a prosecutor to charge. You talked a little bit about sort of the indictment review process and
right.
From a technical standpoint, looking at the various statutory vehicles and assessing the elements. But Abby raised a point about the quality of the evidence in these cases, where you might be able to have some offer of proof that the government believes might satisfy a particular element of the offense. But are you weighing sort of the impact on the program, on the public official, on the system, in deciding whether to charge that case or not?
Absolutely. Absolutely. I mean, we don't wade into every single case for a variety of reasons, but sometimes, you know, it isn't a federal case, or sometimes it's important that we stay off of the field if the allegation or the evidence isn't such that we would investigate, or if the proof isn't there. I mean, I have to be certain when I bring the case that I can prove it beyond a reasonable doubt. Mm-hmm. That's my duty. And we take those allegations very seriously. We take that process very seriously in the Northern District. And I can tell you that it is vetted up and down the line because these cases are so important, and as are all of our cases, but particularly in a public corruption case where it's going to play out in front of the public. There's going to get a lot of scrutiny. People are going to be calling the ball and saying lots of things about it, and we want to be able to stand up in court and be proud of the case that we brought. because of the ancillary effects it's going to have on the defendant, because of, if we bring a case that's half put together and the public sees that, God forbid, they're going to think that 2 wrongs have occurred. They're going to naturally, I don't completely disagree with you, Abby, that they already believe that a lot of people are on the take in state and local governments, in the federal government, whatever the case. There's a cynicism that seems to pervade the conversations that we often have. You just have to read the AJC's comment section to understand that. And if you bring a half-baked case at the end of the day, or one that doesn't seem to play fair, most importantly, well, they're going to believe that 2 wrongs, and the people are not playing fair on either side of the table. For us, it's not about winning or losing or hanging a jury. It's about doing the right thing and being fair in the system, making sure that it gets tried properly, making sure that the defendant has his rights protected. And I know that seems very ethereal, and here we are in front of a panel having this very symbolic discussion, but it's absolutely true, at least in my office. That's the most important thing at the end of the day. So we do. Yes.
I don't spend enough time in northern Georgia, that's all I'm saying.
That's what he just
He's a good
whispered to
egg.
me. Neither do I, apparently.
No, we're quite fortunate to
It's
have.
great down here.
It is.
Come on down.
Quite fortunate to have.
Hold on, I'm sitting at this table.
We're fortunate to have thinking prosecutors in this district, and
Having said that, though, I will say that we do bring the hard case.
yeah, sure.
And we're not afraid to do that. Sometimes it needs to be brought.
Right.
But we're gonna be guided by those principles.
Jenny, when Menendez was indicted, Senator Menendez, you had to make a number of tactical decisions that really seemed to have 2 purposes. You raised a number of important legal issues in a variety of motions that you filed in that case, which I'd like you to talk a little bit about, because I think it's
There
fair
they
to
are.
say, that the defense was very aggressive in motion practice in that case, and it seemed to have at least a couple of purposes. One had to do with the legal issues that are raised here, of course, in these various motions, but the second one was an effort to sort of give the defense a vehicle to rehabilitate the reputation of your client before the trial in the case. So talk a little bit about that. If you can.
Sure. So it was actually this time, the fall of 2015, right after the senator had been indicted, that the first kind of series of motions were filed. Were there 15 or 16, somewhere around that number? And Abby, I think, thinking he was being coy, had me write the prosecutorial misconduct motion, which was interesting to me to have.
Being
that.
coy, I want one of us to be able to get out of New Jersey, and I picked me.
So, as you can see, there was certainly, I think variety is the right word, Mitch. There were a variety of motions that were all filed, and we were recounting this story yesterday. The judge, we had asked for an extension because it was the high holy days, just as they're coming up next week, and we were denied an extension, so we ended up filing all of these, I think 4 days early, which felt good to do. In any event, this was all pre-McDonnell, obviously, and the approach here was to try to attack from every possible angle the issues with the indictment and all sorts of other issues. I mean, we had grand jury bias motions, we had the prosecutorial misconduct motion, we had motions to dismiss. It was just a panoply of different legal approaches that we were taking. And we ended up filing these motions, as I just mentioned, in the fall of 2015, and this didn't go to trial, as you all know, until this time last year. We were actually on trial this time in the fall of 17. So we filed everything and did not argue the motions until sometime later. And the night before we were scheduled to argue all of these motions, and there were so many of them, the court's deputy contacted counsel for all sides and said, you are allotted, I think, an hour and a half each side to argue everything. So we had to divide up who would do what, and it was like an algebraic equation, when things were all said and done. It was insane. And we actually confined our arguments to the time limits, but these were really substantive, important, critical legal arguments that needed to be made, and they were all but dismissed by the judge and the court in this case. So this approach was not as successful as we hoped it would be, but it really is indicative of, one of the ways in which we try to, as Abby mentioned earlier, kind of chip away and get to the core of what this case was about. And that was one of the methods we used.
Later we should talk about this as in the consideration of whether we wanted to rush to trial or not rush to trial. But as we stay on this topic, I don't know, again, always good to have your view, Kurt, about what you think when you see something like this. There were a couple of reasons, obviously, for the motions practice. First and foremost, you don't want to waive rights you have, and you have to file certain motions so that they're not waived. It's a rare case. This is the most number of pretrial motions I've ever filed in a case. I'd like to think they weren't frivolous in the sense that there were reasons why we did them. Everything from the leaks from the grand jury, the fact that the case had 105 witnesses, 36 grand jury witnesses, and in every single one of those, in one way or another, the law enforcement community decided to ask witnesses about the sexual proclivity of a United States senator and other people as one of the many things we raised as to why that would be relevant. And then there were some purely legal issues like a multiple conspiracy charged in a single count, et cetera, like things that you guys do every day. So part of it was the law. Part of it was the counter-narrative, right? Our motions speak. And in the prosecutorial misconduct, it spoke loudly, and it wasn't fun to do that. I don't relish, Jenny especially, wouldn't relish going and saying that her former colleagues in the larger community of law enforcement misbehave, but sometimes we're humans and we misbehave. And so there was a counter-narrative. The third was to help repair, again, remember I said the court of public opinion, to try to explain that this isn't a slam dunk. The fourth was to give his colleagues in the Congress the strength to stay with him so that they did not seek his ouster before the trial. I mean, there were lots of reasons for this particular strategy. But before I leave motions, I do want to offer the Abby Lowell Prize to everybody here. There are 2 motions that I file in every criminal case. Someday it's going to work. Thus, once it's never, and if any of you get them to work, because we now have realized that the Northern District of Georgia is the most enlightened district, here are the 2. Think about the following 2 things. One, I'm serious about both, but this is a political case with high-profile media allegations of wild activity. When we go to trial, we voir dire the jury. Who's a Democrat, who's a Republican, who hates Menendez, who hates whoever, who's lost money in a securities case, and it's a securities fraud case. We don't let a jury walk into the box with that kind of preordained bias, right? We build our system on it. It doesn't happen in the grand jury. There's no screening of a grand juror for the same issues of bias. And there's law out there that says there should be an unbiased grand jury. If we believe that the grand jury is supposed to do anything, we could have a whole session on whether the grand jury does anything, but let's assume we're going to pay it lip service to the idea that it's a shield and not just a sword. And so in every case I have done for 100 years, it's actually a joke in my colleagues that I filed the same motion and have never gotten anywhere with it, and always asked to dismiss an indictment because the grand jury wasn't screened for the same bias that you're about to screen. So if you guys will get that motion, make it better, make it your own, and any of you win, you get an all-expense-paid trip to Washington, D.C. or wherever, so that you should do. But that's one of the motions we did. And I bring that one to your attention because it's not, funny aside, it's actually an interesting thing to think about.
But to that point, I argued that motion in the 4 minutes I was allotted, and the judge's response to the argument was any bias that occurred in the grand jury is cured by the pedigree. That was the answer, which is, I think, counterintuitive.
Kurt, I want you to respond to Abby's question about sort of, the pretrial proceedings and the impact on the case and the defense's efforts to try to rehabilitate the tarnish to the image of a public servant caused by the indictment itself. What's the government's strategy in these cases when you're faced with motions like the ones that Abby filed?
I think sometimes we see, and I'm sure that's not in Abby's cases or Jenny's cases, but we see the motions are filed as placeholders, just to buy time. So that can be a little frustrating when the motion is not well placed, when we're just kind of off on a detour in order to get 6 months to review discovery. I mean, honestly, when we bring a case, we're ready to try it. We'd like to try it as quickly as we can. It's important that we do. I think that for the public, it's important that we try it in close proximity to the alleged event. There's a justification there. People move on. There's a 24-hour news cycle, and if you try it 8 years from now, it doesn't have the impact that it would otherwise if you tried it in more real time. The rehabilitation, so that's a discussion that occurs on both sides, and there's always a narrative and a counter narrative that's proposed, and so if we are engaged in pretrial litigation, there's often a chance to put my theme out and to put what is important to me in the case out in my pleadings. And those will often be seized on as the counter-narrative. So it goes both ways.
I mean, a couple questions for you. One, you raised the point of whether you want a quick trial or not, and I'd be interested in you sort of going to that slide and talking a little bit about that. And then the second question I have, which is really sort of unrelated, but I just tee it up. It looks like that, to me, from the outside of both of these cases, that Edwards was a different kind of defendant than Menendez, right? I mean, the public perception of Senator Edwards was not the same as the lifetime of service image of Senator Menendez. Mm-hmm. So I'll let you go with go first with the speedy trial issue, but I'm also interested in sort of how you navigated, what your strategy was for one kind of defendant versus another.
And I think that is a commonality for all of our cases that go to trial, whether it's public corruption or not. You can have an enlightened CEO that people like. If hypothetically there had been a case brought against Steve Jobs, is different than the person who was the CEO for the BP oil mess, where people may think of you differently. But we'll come back to that one. Though again, this is applicable to every case, what I'm about to go through with you all. And it was certainly ours. And we were with Rob Carey last night and yesterday, who was one of the people on the Senator Ted Stevens case. And that case was one in which they opted for a speedy trial. And I think the trial was literally like 70 days or so after the indictment. So I'll talk a minute maybe about that, or half a minute. So look, maybe this is applicable to the decisions you make as to whether move ahead quickly. Maybe it's not. Maybe it's only unique in a public official's case, but I want to tell you what these were. So when we were thinking about what to do, so the indictment is on April 1st of 2015 for an investigation that had become public by the end of 2012. So it's already been 2.5 years. There's 3 years before the election, his election. But the 2016 presidential campaign is well in swing of things. And so politics plays a role in public corruption cases. So we had to figure out with our client, what did he want, what was best to succeed. Remember, the first criterion in these cases is the law. How do you keep your client free? Then comes the politics, then comes the court of public opinion. So here's what we had to grapple with. The first pro for going fast would have been to give us the most time before the 2018 election so that he could regroup, assuming we won, and that was the idea, of course, that he could rehabilitate his reputation and he could be strong, and this would be in the rearview mirror by the time, and right now he's up for re-election, the trial having ended in November 17. You can imagine that his opponent, a self-funded pharmaceutical executive in New Jersey, had a choice for his TV ads. His TV ads could be about, this is what I'd like to do to improve the economy of New Jersey, or why would you put in a place a senator who's so corrupt? Guess which one he's running. So we could have had more space between the time of the trial and the time of the election, so that was a factor. On the other side of that, I love your candor, and I've heard it 100 times, Kurt. We want to try it. We're ready to try the case the moment we bring it. So as my kids used to say when they were a lot younger, duh, I mean, you've been doing the, the investigation for like years. We're just hired. And I love this part, when we go for the arraignment and we pick a schedule and the assistant U.S. attorney gets up and says, Your Honor, the government is ready to try this case. And like I go, yeah, and I was hired 3 weeks ago and I'm not. So, you have less time to catch up. And this was a case with a 3-year investigation, 105 witnesses, 36 grand jury testimony. I never know the difference, like 11 gigabytes of information, and so that's the con. Notwithstanding what prosecutors say, Your Honor, the government's ready to try the case, it turns out that sometimes they're not. And even if they are, their witnesses aren't. And even if their witnesses are, the scheduling is horrific. I mean, there were dozens of witnesses in the trial. So putting the government to its test of the burden of proof, it's like, okay, bring it on. You ready to go to trial? That's not so fun sometimes. That's on the pro side. On the other hand, you just saw what Jenny said about the motions. So you forego a lot of that, or you make them pro forma if you say, I want a trial in 70 days. So you would do that. One caveat in the case of Menendez, you need to know we had a unique opportunity. He's a sitting member of Congress who can enjoy in a public corruption case a constitutional privilege called the Speech or Debate Clause, which means that members of Congress should not be questioned outside the House or the Senate for what they do or say as members of the House or Senate. And the joy of this is that it's constitutional, and so if you lose the motion, you can take an interlocutory appeal immediately to the Court of Appeals. And you can also then seek cert to the Supreme Court, both which we decided to do, again, for the strategy that we didn't need a speedy trial. But you forego some critical motions. The second thing was, the third factor is you capitalize, that's why we wrote maybe, on political atmosphere. This was an election year for the presidency. It was a very hot and contested race. The candidates were very polarizing. Menendez was somebody who was seen as not that kind of public official. And so you could posture if you think that the jury pool would have been paying attention. On the other hand, as more and more facts became known about the case, there were more people saying, hey, how did this case get brought? Why was it brought? Is there politics? And so you would forego the buildup of criticism. And then, of course, if you have a co-defendant case, you have to take into account the needs of the co-defendant. In this case, by the time we got forward, the co-defendant had been charged in Florida in a separate event while he had been allowed bail in New Jersey. He was not allowed bail in Florida. So now we had an incarcerated co-defendant, and that changes the dynamic of whether you want a speedy trial. If you go faster, no matter what, depending on your financial budget and your ability to raise funds, you'll spend fewer funds if you try a case faster, and you'll spend a lot more money if you're going on interlocutory appeals up and down and up and down. So those are the factors in speedy trial. And some of these would apply in a corruption case, some would apply in every case, and I think that's worthy of consideration. I have to tell you that in no case, I think I'm up to 30 or 29, I have to get this right, criminal cases for as a defense person. I have never sought, I've never had or sought a 70-day trial, or even 80 or 90 days. So, but those are the factors. One quick word to move it along on your question. I know it's not related. But again, I think your cases are the same. Every defendant, every client you have is different. And when you try to think about how you're going to present your client's story to either a judge, a jury, a prosecutor for please don't indict my case, you have to figure out what your client's persona is to the person who's listening. And you have to pay attention to that. And that's why you strip away what the charges are to what is that art. So to use a great duality, I mean, Bob Menendez, parents flee from Cuba, great American story. He gets himself elected to the school board when he's in college, puts himself through college and law school, public servant all of his life. His total accumulated wealth as a 35, 40-year public official is like $3.98. All he's known is public service. He's, whatever else you think about him as a person who's given a lot of service to the United States. John Edwards, a slightly different story. I mean, man of no particular wealth, also came from virtually nothing, great American story. Very successful plaintiff's trial lawyer, candidate for public office, Senate, ran for vice president, very articulate, and because of what he did, had a different persona. The Charlotte newspaper, 2 weeks before the trial in Greensboro, North Carolina, did a poll. There were two parts I remember distinctly. One was ranking people, likability or hate, who was the most hated person in America 2 weeks before the Edwards trial. Pretty sure I'm right about this. There was Osama bin Laden in front of him, and there was somebody else, and then there was John Edwards. That was not good. And the second was 79% of the people polled said he was guilty. I'm not sure they knew what he was guilty of, but they thought he was guilty. So again, you had to come up with a theme, and as I said, the theme we came up with is that we invited the jury to hate him as a sinner, and we welcomed the jury to remember that their role was to apply the law, and that was the concept. With Senator Menendez, it was to remind people of his humble beginnings and to dwell on the friendship. But I'm sure you guys have to always tailor your presentation to the differences of your client. And it's not one size fits all, and maybe we think it is, but it's not.
Right. So, Kurt,
And so, let me riff off that
Yeah.
just a second. So we did a couple of years ago, more than that now, a case involving a state representative who was a civil rights figure who was well known in the community. He was a contemporary of Martin Luther King's and had a lot of support in this community,
Right.
was very well known. And so we prosecuted him for embezzling from several fake charities that he created in order to support his lifestyle. And it comes to light that he has essentially been raising money from large corporations, and in doing that, he's diverting the funds to himself. He's not living lavishly by any means. He's living very modestly, but he's stealing. And over the course of 5 or 6 years, it's about $1 million or so. And so when we brought that case, speaking of themes, we were very cognizant of the fact that this was an individual who had served all of his life in public service. He was a civil rights leader and dedicated his life in that regard. And he had much to commend him to the public and to a jury. We chose to focus on the fact that he was a good individual, but good individuals make mistakes sometimes. And it was a sad day to bring this case, but it was an important case nevertheless.
and that's what I was going to ask you, is that from the government's perspective, you've got to establish you want the jury to be focusing on the quid pro quo. I mean, the
On the crime.
act or acts
Right.
that constitute the underlying offense, as opposed to the sort of broader scope of the conduct of the public official. And that's the proof that you're analyzing and deciding not only to bring the charge, but how to try the case.
That's right. That's right. And you do that in the context of the individual and who the individual is and what his or her accomplishments are. But my job is to focus on the crime and proving the elements of the offense, not to smear the individual.
And so there was a mistake in that regard in the Menendez case, right, where the government tried to make something of Senator Menendez's dedication to protecting the New Jersey ports, and then forgot that that wasn't the result of a bribe, but actually there was a long history of public service that was unconnected with corrupt behavior.
So Mitch, you were just, highlighting the point that you do, at the end of the day, need to prove a quid pro quo. And thematically, throughout the course of at least the Menendez trial, what the government, I don't know that it was a mistake or an oversight on its part, failed to acknowledge the fact that the senator had long-standing positions on policy and positions on many of the things they claimed were the quid pro quo in connection with his relationship with Dr. Melgen. And that's why Abby just brought up the slide. There was a commercial for Menendez's 2006 candidacy, basically his campaign, and the commercial was all about his intense interest in port security. And one of the alleged bribes was that he made calls or arranged meetings on behalf of his friend Dr. Melgen in connection with a port security contract that Dr. Melgen was involved with in the Dominican Republic. And the way we combated much of this was to show, and it was not easy given the judge's refusal to allow any meaningful evidence in on our part in the senator's defense, but he had these long-standing policies and practices that really chipped away at the government's theory that there was this favor being done for this person in his life in exchange for something. There simply was no exchange. And I think that was a really big problem for the government in their trying of this case. And that's why the way, kind of our theory of the case with the friendship was to get this friendship or the evidence of the friendship going back as far as we possibly could to show the jury contextually how this friendship occurred and what the senator's positions on these matters were over a very, very long period of time.
Kurt, yeah, go ahead.
Given what you just said, Jenny, about how important it was to emphasize your theme of this long-standing friendship, can you talk a little bit about how you decided not to put Menendez on the stand? Because obviously he's sort of like the best evidence of his values, his beliefs, his friendships, and what other kind of evidence you use to really prove or hammer home that theory?
Sure. I mean, the decision whether or not a defendant, especially, Oh, I'm sorry. The question is really aimed at why it is the decision was made for the senator to not testify at trial, because he would be, in essence, the best witness of the quarter of a century long friendship with Dr. Melgen. And it's a very good question, and I think probably could be the subject of an entirely different panel, whether or not a defendant testifies. And I'll let Abby speak more to kind of the process we all went through in making that decision. But to answer the latter part of your question, what types of evidence were adduced at trial to show the friendship, we put on a case. And you can get in your evidence a number of ways. It's through cross-examination, of course, of the government's witnesses. So in our themes during cross-examination, we tried to emphasize the longstanding friendship through that method, cross-examination, and certainly through the witnesses we called to the stand to testify. We called his son, Rob Menendez Jr. He's not a true junior, but they call him junior.
Now.
He is now. Yes. So he was called to the stand, and he could testify about, and I think there's a slide on this, how he knew Dr. Melgen for so many years, and they took family trips to the Dominican Republic, and he referenced him as Tio, which is uncle in Spanish. So it was through testimony like that we were able to establish the longstanding friendship. And also just the amount of trips that the senator took to the Dominican Republic, paying his own way on commercial round-trip flights. So the nature and length of the relationship, we were able to get all of that before the jury through the witnesses that we called to testify in our case.
So they had made whether it's a mistake or whether or not it was a strategy to suggest that Senator Menendez, concerned about New Jersey port security, was of recent vintage and induced by corruption and gratuities or payments from Melgen. That was one, and then you got the campaign ad to show that it was of a long-standing held belief and concern for the community.
Right. So from the government's point of view, just one thing. Look, once they decided to go forward with this case, they had to. We didn't pull a rabbit out of the hat to come up with the fact that they were long-standing friends. The government knew that was going to be a central part of our defense. So they had to come up with a rebuttal concept. And the rebuttal concept was friends can bribe friends, which I think I don't think that was an effective thing, but that was what they came up with. And the second thing about it is that even if you are inclined to do something, if you take actions that are above and beyond the call of duty, it's one thing for Senator Menendez to be for port security. But why in God's name would he be calling officials about a port security contract in the Dominican Republic that has nothing to do ostensibly with what's going on in New Jersey? That might have been a mistake, because we were able to point out that the majority of cargo coming out of the Dominican Republic goes to the 3 ports in New Jersey. So, I mean, but you see the tug of war. To answer your question, look, I want to ask you this too. Every juror wants to hear from the defendant in a white-collar case, right? They do. And we've had to face it. We know that. We talk to jurors. We knew that. That's always been the case. Rarely have I put a defendant on the stand, including, by the way, that John Edwards, one of the great speakers of all time, did not take the stand in his own defense. There's always a reason for that. In Senator Menendez's case, we can't dwell on it, but there was a couple of other counts. One was that he had filed a false statement on his financial disclosure form. And another one was that the government played a tape of his being interviewed on CNN after the indictment, in which he wasn't knowledgeable about the facts, and the statements he made were not accurate. And so we had to take into account that he would be beaten over the head if we put him on the stand with those things. So they had their video, we had ours. Senator Menendez speaks in this ad. And he talks about his passion for New Jersey and for his concern about port security. So on the issue of port security, I had my client testify. I just didn't have him testify in person. And so we had that ability.
Good morning. Can I ask a question? It kind of goes back on to preparing your case, your high-profile case. My name is Tiffany Simmons. I've handled high-profile cases here in Georgia. However, I have a boutique firm. So what are your thoughts or tips out there for clients, attorneys that have boutique firms that deal with high-profile cases? Because my last high-profile case, I just remember the interchangeability between the political side, the public opinion, the things that you mentioned. And it was very difficult to navigate when you're dealing with the real-time issues on top of the actual facts of the case, preparing the case, and the public. So just any tips do you have for...
I have a few. I don't want to monopolize the answers, but I have a few. I've said this to people. This system is a great system we have. It's the best on the planet Earth, but it works best for those who have means. And for those who don't have means, it doesn't work as well. And even, believe it or not, a senator of the United States didn't have as much means as people think, but probably more than the average person that you might be representing here. Remember, for his means, the other side had lots of means, 105 witnesses, 36 in the grand jury, 5 prosecutors at the table, blah, blah, blah. So you make do. So here are the tips. Take jury consulting. You might not be able to afford a jury consultant, but you might be able to run your own focus group by organizing it internally among your friends and community. And I definitely have done that in an occasion or two. Nowadays, in the old days, you needed to hire a fancy schmancy graphics company to do some of the things you see on our screen. I'm not good at this because I can barely turn on my iPad, but I understand people are pretty good at PowerPoints and things, and they work pretty well. And I'm sure among you all, you know how to, you could do that. And therefore, you can have a pretty nice graphics package that didn't require you to spend a dime outside of making sure it was on your computer. That's the second thing. Third is, if you're representing a high-profile person, they didn't get to be a high-profile person overnight, and they have a history. They have a network of people. They may be in a company. The company has a PR aspect, a communications department, could be a public official. They have a press spokesperson. You tap into the resources of the clients that already have some resources in their repertoire. So those are 3 examples of having the ability to do what big law firms might do, even as a boutique firm. I think I could think of others, but you just have, I certainly understand what you're saying, and you have to make do. But there are some tricks to the trade about doing that. And now, while I get concerned about the overabundance of electronic discovery, but by the same token, electronic discovery allows you to not sit in a room with mounds of banker boxes filled with documents, but now you can do selective word searches for looking for things. So, you can figure some ways out. Not perfect. It would be great if everybody had the same resources, but those are some things that come to mind. Do you feel like do you feel like you're unlimited in resources when you're doing a case? And the second question for you is, do you salivate in every case of a public corruption, hoping beyond hope, oh, please let the defendant testify, oh, please, oh, please, oh, please? Do you do that?
I do. I honestly do. It's it's unique. It's often somebody on the other side who has made their life and made their mark by being a public persona, by being able to capture a room, have a conversation, be the most important person in the room, be the most jovial person in the room. And so they come to the case sometimes. I mean, every defendant is different, every client is different, but sometimes they come in with this persona that is around them, and that can be a very double-edged sword when you're testifying in a federal trial. And we are pretty meticulous, we hope we are, in preparing the important parts and trying to focus on the case, focus on what the facts are. And so certainly none of your clients, but when you have somebody who comes in who has been able to talk his or her way out of many a jam, that's a difficult position to be in a federal trial, as you well know. So our resources are not unlimited by any stretch of the imagination. I do a lot of the document reviewing and work myself, as I'm sure you all do, along with my agents. We we spend a lot of time figuring out how to do these cases and do all of them with the 103 prosecutors who are not dedicated to public corruption in a world where electronic discovery is multiplying every year. You know, it used to be 100,000 documents or 10,000 documents. That was a big case. That was a very big case. And we have a case now that is literally millions and millions and millions of documents. And to be able to go through those in a way that meets my threshold for bringing a case requires a lot of time and effort and, frankly, just a lot of weekends.
So we have about 15 minutes left. I want to leave a little time for questions.
Can I do one more thing, though, before
Absolutely.
questions? I mean, in a public a corruption case, we would be remiss if we didn't tell you one more thing, because I've had the occasion to do this in a number of cases, and it comes up all the time. And your clients are going to ask you about this, and that's the issue of character evidence. In any white-collar case, you have an opportunity that you wouldn't have in a non-white-collar case to bring somebody to the stand on a critical issue of intent or motive or of personality that you can. And if you have a bulletproof client with the right kind of character evidence, prosecutors are virtually powerless to do something against it. Now, if you have a client who has a record and opens the door, weren't you the person who kidnapped the Lindbergh baby, and you know the rules. You open the door pretty wide when you put character in. But if you have this ability, I think it's underused. And in Menendez's case, you asked about testifying. Well, again, Jenny said we had Bob Menendez Jr. testify. We had our co-defendant's wife testify about their relationship. We had a campaign ad. We could get people testifying without it being our client, and we could also have character witnesses testify in place of our client, and we did. And you don't have to put your client on the stand in order to have a character witness talk about a trait in the trial that's not necessarily his honesty and testimony as much as his law-abidingness, which is one of the traits that you can have a character witness opine about. So I commend you to that. In this case, Bob Menendez is a lifetime of service. We had two amazing character witnesses. They weren't just public officials. I have a very strong view that you need the butcher, the baker, and the candlestick maker. You need the priest, you need the public official, you need a person who your client has helped with that is unsung, the person that looks like a juror, as well as, the person who's the most well-recognized. So we were lucky to have two on the opposite side of. We had Senators Lindsey Graham of South Carolina, a Republican, and Senator Cory Booker, his co-senator in New Jersey. They were amazing. They were our witnesses on the last day, and they were bookends at the end. And Lindsey took the stand and, among other things, said, we're different parties, we disagree on everything under the sun, but there's a man that I would turn to for honesty and integrity in the United States Senate, and that's Bob Menendez. And then Cory Booker, made me cry. He went on and on about how there's nobody who has his back, and he told stories he shouldn't have been able to tell about walking the streets of New Jersey and blah, 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 and Newark. But that's powerful. And of course, the prosecutor only has two things they could say in a situation like that. It's either you know this person, you like him, you don't want to see anything bad happen to him, isn't that right? And we have a rebuttal to that when our witnesses are done. And then the other one would be, and you haven't sat here for 11 weeks and heard the evidence against him. But that's about it. But then, in the Menendez case, we didn't get a lot, but boy, one thing we did get was the best character witness instruction that has ever been given in a courtroom in the United States of America. And how we got this is a mystery, but
I have no
thankfully we
idea
did.
how you got that instruction.
Yeah, I don't either. We got it, and now it's been given, so now I commend all you defense attorneys to say to your judges around the country, hey, this was given in a court of law with Senator Menendez. So, part of this is standard. There are circuits in the country in which you are allowed, in fact, mandated to tell a jury that character evidence alone can create reasonable doubt. That's a powerful sentence in itself. Here, he embellished it in ways that we had asked him to, and he did. Basically saying character witnesses of the same kind as anyway, you can read it yourself. But the point is that character witness evidence in public corruption cases are something to consider. Of course, remember, it opens the door really wide. Sorry I took that piece, but I thought character evidence was important. Ask away.
Yeah. And so you always try these cases with a path to give the give the jury a way to get to a not guilty verdict. Abby, do you want to talk a little bit about that path and the Menendez?
Everybody has their device. This is mine. Whoops. This is my device. Probably, dozens of times. At the end, in my closing of my closing, I give a jury a summation as to the path to not guilty. In this case, I wanted to emphasize reasonable doubt. You don't have to, but I think that's always good from a defense point of view. And literally, you try to bring it down into, remember, you chip away what's not the art. So these were things that we all agreed upon would do it. You don't have to know the case to see some of those, but this was literally a slide. I ended my closing argument by quoting Cory Booker. And I said to the jury, I'd like to conclude, and I've been trying to figure out words that would make sense to you after 11 and a half weeks, and I can't. And then I realized I didn't have to, because the most important thing you heard from Cory Booker, and this is what he said. That's how I ended the closing. But before that, I did this, and this was a list of how the path. You're going to go into you're going to go into the jury room. You're going to have 18 boxes. You're going to have thousands of exhibits. You're going to have testimony. People are going to go, I don't know what to do. I don't know where to start. And I said, I'm going to make it easy. Your job is to determine whether they have proven their case beyond reasonable doubt. If they haven't, then you have to acquit. The judge just told you that. I will give you the way to get past those 20 boxes, those umpty-ump exhibits, the senators. This is your path to not guilty. And that's what I did.
Questions for the panel? Yes.
Initially, did you talk, Senator Menendez is a very well-loved graduate of Rutgers University Law School, which is a state university of New Jersey. And in your voir dire, we were able to determine whether there were any Rutgers graduates. What was the composition of your jury?
You remember the composition? I feel like I do. Go ahead.
It was ever changing.
A little
I thought
changing.
it was even in terms of gender. I think we had 6 men and 6 women to start with. We did lose a very important juror during deliberations.
6 men,
Yeah.
6 jurors, 4 or 5 people of color.
Yeah.
Age range, pretty much education range, not top end, nobody with like a PhD in nuclear science, but nobody that didn't have a high school education. What else did you say? 6 men, 6 women, 4 or 5 people of color. And yes, we were able, and then, back to your point about what you can do in a boutique firm, welcome to the internet. Jurors have, like everybody else out there, they're open books. They have social media. You can find out quite a lot about people, and the ethics of doing that is just fine as long as they're public. You can't friend somebody to go figure and entice them, but you can look in what they've said about themselves, and the internet will tell you quite a lot about your would-be jurors if you have the time to do it. And that doesn't take a lot of money. It just takes getting to know your jurors' names prior to having to pick them. So we knew where they went to school. We knew what their party affiliation was. I knew whether they had given any contributions to any party, blah, blah, blah. So that answers your question, I hope.
Yes.
Along that line, did you use a juror questionnaire? What strategy did
Yeah.
you have as far as what type of jurors were you looking for that you would like to have seen?
I don't understand why every judge in America doesn't give a questionnaire anymore. I grew up when that was a changing thing, but now prosecutors and defense attorneys kind of want these. And we did. We just didn't get all the questions we wanted. We wanted detailed questions about people's political activity and stuff, and the prosecutors wanted, like, did you ever support Menendez in a campaign? And
Right.
We wanted to know whether people had good or bad experiences with Health and Human Services and blah blah blah. The point is that we did get a questionnaire. It wasn't the one to our liking. It wasn't the one to the prosecutor's complete liking. It probably never is. I thought he was stingy to both of us in ways that he shouldn't have been. It's too complicated in a short time to tell you what kind of juror we were looking for. As you guys have told your loved ones, right? I always tell my classes that I teach, and anybody who will listen to me, that it's a misnomer to say you pick a jury. You don't pick a jury. You de-pick a jury. You deselect a jury. You're kicking off those people for whom you think there's a reason that they won't be fair. And with only 10 and 6 peremptory challenges, what I was trying to do is get rid of people that for whatever reason on the criteria, looked like they had a predisposition. By the way, one more thing about our jury, it only had may have only had one Republican or two at best, and it had a number of independents, and the rest were Democrats.
And to that point, the one Republican, which I think made us a little bit nervous, was an alternate and ended up filling a seat of a very valuable juror who gave interviews from her kitchen after being released during the deliberative process, saying Senator Menendez is not guilty, let him go. He filled her seat, and we were a bit nervous, and ended up being, I think, an excellent juror, and spoke with the media. He's the reason we knew it was 10-2 in favor of acquittal. So it just goes to show, the one acquittal I had as a prosecutor, I thought we had the jury, and one of the jurors even commented on what a great job we were doing, and we, of course, informed the court of that when it happened, and it was an acquittal. So you honestly never know.
Kristen?
What was your view on trying it in New Jersey? The desirability of being in New York?
Wow. Somebody planted that question. The first motion I made in the case was to move the case to the Washington, D.C. I made a Rule 20 motion. So I have to be careful here. We had two contradictory theories in our brain. One was I thought the jury pool was better in New Jersey than where else it might sit down. It could sit down in Washington because all the events of any significance happened there. We had legal grounds. In fact, in certain ways, they had no reason to be in New Jersey. Not any event except a flight leaving Teterboro Private Airport one time went in New Jersey. The official acts were in Washington. The place that they sat down was the Dominican Republic or South Florida or Washington. Literally nothing happened in New Jersey of any significance other than it was the place he was. In fact, the prosecutors started the grand jury in South Florida and then moved it. So that's one. So we liked the jury pool in New Jersey because they liked him. I thought that the judiciary in Washington would be more receptive to the motions practice that we knew we were going to, and not the least of which was the speech or debate clause, something that a lot of judges around the country don't have a lot of familiarity, and people in Washington, at least theoretically, have more. So the weighing of the scales was, and it's not like I didn't know that the D.C. jury pool wouldn't be okay. We knew that too. So that was the decision making. Ultimately, he didn't grant it. I thought we came out well with the jury that we had.
Kurt, would you be reluctant to prosecute a public official outside of his or her area where their constituents reside?
Or do you prefer to do it?
Or do you prefer to do it there?
I mean, we bring the case where we have venue, and recognize.
But you have choices.
But we do. But we're pretty constrained on where we can bring a case, where we can indict a case, and so that is a consideration. But we take into account the fact that most of the cases that we do, at least in Atlanta and the Northern District, you're going to be trying it probably in the jurisdiction where the defendant resides, or where he has built his name, or where he serves as an elected official, and that's something that we take into account. Now, we're not talking the Menendez case. We're very much more localized in the vast majority of our cases.
There's more than one choice, but it's not vastly different. In the Senator Ted Stevens case, you remember Ted Stevens from Alaska. The government brought the case in Washington.
Right.
Ted Stevens sought to transfer it to Alaska. The government objected and saying that it should be in Washington because that's where a senator really lives and that's where the actions really occurred. Then the same attorneys in the same section of the same division of the United States Department of Justice in the Menendez case said, when we said let's bring it to Washington, just like you did in the Stevens case, said, no, a senator lives in his home area and it doesn't matter that it's there. And when we raised that to the judge, his response was, do you remember those words? What's the word? No, that's not what it is. No, it was. I'll try to be quick about it. If I can, I'll paraphrase it. It was, consistency is not necessarily an important point in the law.
And if I can add to that, this is a fun fact about this judge. And Craig Carpenito was here yesterday talking on a panel, and he tried the Sendin case. Forbes was the defendant in that case,
Right.
and I think there were 3 trials.
Right.
And Judge Walls, who was our judge, presided over that matter, and a motion was made, Rule 21, to transfer venue to Connecticut, and the judge determined that it should indeed go to Connecticut, which is where the case was tried. We also referenced his very own case and the Platt factors and walked through each and every one of them because we had a very compelling case.
You know, there are 10 factors in the case law as to what makes for a transfer. We had 9 out of the 10 on our side.
And to your point, his ruling again was that
Don't read my former opinions. This is a new case.
nothing to do with this case.
Anyway, but you have some choices, but not, you're right, not as,
Yeah,
but
yeah,
it's
I mean-
interesting about the Ted Stevens things, right? Stevens won it in his home state. I pretty much did, but there was a reason on the motions practice. But I'm telling you, the public integrity section took diametrically opposed positions on a matter of law on 2 different cases, both about senators. Go
And
figure.
you could argue that Senator Stevens was probably as closely tied to his home state as almost anyone sitting in the Senate. Any other questions? All right, I think we've reached the end of our allotted time. Thank you all for